Thank you. My name is David Fewer. I'm the director of SIPC, the Samuelson Glushko Canadian Internet Policy and Public Interest Clinic here at the Faculty of Law. And I've been asked to moderate the second panel on privacy and security in a globalized world. I'll introduce our three panelists before we get going. Luke Arbuckle is Director of Analytics for Privacy Analytica, Inc. He is co-author of the book Anonymizing Health Data, Case Studies and Methods to Get You Started, published in 2013. The book covers several de-identification projects he's worked on, such as the $3 million Heritage Health Prize, and Mount Sinai's World Trade Center Disaster Registry. He joined the Electronic Health Information Laboratory at the CHIO Research Institute in 2010, doing research devoted to facilitating the sharing of electronic health information for secondary purposes while protecting patient privacy. Our second panelist is David Fraser, who is a partner at McInnes Cooper in Halifax. David is well known as one of Canada's leading internet technology and privacy lawyers. He regularly advises a range of clients from startups to Fortune 100 companies on all aspects of technology and privacy law. He's the author of the popular Canadian privacy law blog, which is mandatory reading for those of us in this space. And he is also particularly well known for his work on transborder data flows and law enforcement and national security interests in customer data. Finally, Michael Geist, my colleague, he is the Canada Research Chair in Internet and E-commerce Law here at the University of Ottawa. Michael is a law professor here, where he holds the Canada Research Chair in Internet and E-commerce Law. He is a syndicated columnist on technology law issues, with a regular column appearing in the Ottawa Citizen and the Toronto Star. He's the editor of a number of well-known Canadian copyright law texts, and he's received numerous awards for his work, including the Public Knowledge IP3 Award in 2010, and the Electronic Frontier Foundation's Pioneer Award in 2008. He was named one of Canada's top 40 under 40 in 2003. In 2010, Managing Intellectual Property named one of the 50 most influential people in intellectual property in the world, and Canadian Lawyer has named him one of the 25 most influential lawyers in Canada in 2011, 12, and 13. And without further ado, I'll hand the panel over to Mr. Arbuckle.
Thank you very much. Thanks. So I have to admit, first and foremost, that I am a data scientist. What that means is I have learned things about people from data, but I'm not the bad guy. I originally started doing work, things like learning things about healthcare outcomes, trying to figure out how long someone would stay in a hospital, their length of service, for example. This was used to better inform practice. That was the idea. This was some of the research we were working on. I then took that knowledge and joined the Electronic Health Privacy Lab with Dr. Elamam to work on hiding people in data. So we looked at first at re-identification risk. What is the likelihood that you can find someone in a data set? And that's what I'm going to talk about today. I'm not going to talk about learning things about people, necessarily the attributes about them. We call that attribute disclosure. I'm going to focus more on identity disclosure, finding people in data. So the first thing I want to talk about are the known attacks. You're going to hear about these. You've probably heard about them already, but I want to talk a little bit about them and put them in context. There are some that just came out recently. New York Times last month mentioned some of the exact ones I'm going to talk about now. Then I want to talk about standards and methodology. People think that you can't hide people in data, but there are ways to do this. There are ways to manage the risks. And then finally, I want to talk a little bit about that methodology and talk about how this actually happens at a high level, of course, no technical details per se. So the well-known re-identification attacks. As I mentioned, there was a New York Times piece, Bits and Bytes blog, I think it was about 3 weeks ago now, where they talked about exactly these three examples. The first one you may have heard about already. It was the AOL search data. AOL released a whole bunch of data about people, their search queries. They took out their usernames and they replaced it with some sort of pseudonym. So it seemed like a great thing to give for research purposes. Lots of great information in there. I was at a conference 2 months ago, about 2-3 months ago, and a researcher in this field of what we call re-identification risk mentioned how he has this data still today on his laptop. The problem was that people were identified. So first, it started off with a New York Times article. They used the information you see here to try and locate a person in the data. We call this a demonstration attack, proving that you can find someone in data. So you'll see they have things about something sort of related to their age, looking for 60 single men. They had a dog. They were looking specifically at a certain geographic area, Lilburn, GA. Homes sold in Shadow Lake subdivision, so very, very specific to where they are. And this reporter used that information to find this person, Thelma in this case. So what they ended up happening, besides the fact they identified this person, they got permission, of course. They found her and said, "Do you mind if being this really cool New York Times piece?" And so as a result, it led to litigation. I think it was the class action lawsuit resulted in about $6 million, I think it was the fine in the end. And also a lot of embarrassment. This caused a lot of grief for AOL, as you can imagine. But one thing I want to point out is that all they did change were the usernames. That's the only thing they changed in the data. And in fact, when you dig a little deeper, a lot of the search queries in this case, well, Thelma was the only person in her retirement community that actually knew how to use the internet. So a lot of the search terms had nothing to do with her whatsoever. You know, no one ever talks about that, but I think it's kind of a neat factor. But anyway, they still were able to find her. That's the key point. The next one that was mentioned in the Bits and Bytes blog was the Netflix movie ratings, right? What they wanted to do was the kind of stuff I was doing originally, right? They wanted to predict something in the data. So they took this data, they gave it in a competition. They said, here, we're going to give you this data. We want you to come up with the best model to predict movie ratings. So I liked a certain set of movies. What are the movies I'm going to like next? Amazon does the same thing with books, right? But what the winners of this competition did, the researchers in this space, they took the movie ratings data that they had from Netflix, and they went to another database, the IMDb, which I believe still exists, which also had movie ratings. So at the time, these two were competitors, Netflix and IMDb, and you would go online, you would post ratings, you'd have a username, and you'd post various ratings on movies that you liked, but you'd post it on both of them, because you didn't know who was going to be the real winner in the next 5, 6 years, let's say. And so that's what they did. They took that data, they did some really neat matching algorithm, and they matched the two data sets together. Kind of a neat idea. Again, the usernames were only replaced with pseudonyms. Nothing else was done to this data. And they matched it to a data set that was itself also public. So they found the usernames about these people. They never verified the matching, which is a problem in this research area. We say, we look at this, we go, well, how did they know it was actually the right people? There's a question there. But it still gets a lot of attention, right? It's one of these really popular attacks. And this is my new favorite one. This came out just last month in the journal Science. So big deal. It was in Science, right? Everyone talks about this. What they did was they took credit card data and they looked at, of the people in this credit card data, how many are unique? If I take 4 transactions, so I have the date at which they made the purchase, I know where they made the purchase, Starbucks, the gym, Good Life Fitness Center, and how much they paid. If I know those 3 pieces of information, I can now identify 90% of the people in the data. So they claimed. Here's the problem. Look around you in the room. I'll guarantee you that there are people in this room that are unique based on very simple demographics. Age, gender, let's say ethnicity, right? Those 3 things alone, there are people in this room that are unique, right? But they're not necessarily unique at the University of Ottawa. They're not necessarily unique in the city of Ottawa. So this data considered unique in the data, but not unique in the population, which in my field of research, where we're doing estimation, trying to see how unique they actually are, that's kind of critical. Because I don't know if you're in this data set or not. It was only 3 months of data. They didn't tell us where the data was from. We know approximately, we believe it was Turkey, and so we're talking about a 5% sample of the data, right? It's not representative. A bit technical there, but you can also look at the assumptions they use for that, and it doesn't quite fit. The point being, this is my new favorite because it's getting a lot of attention, but it's not really great. Okay, so we've seen some of the attacks, and the focus of this talk is supposed to be about open data, and this applies. These were all open data sets to some degree. The credit card one isn't quite, but it's in the same vein of all they did was take out the demographics, and they looked at data and said, oh, there's uniques, right? So what can we do? That's the next question. So there are standards that exist, right? The best practice guideline, this is a Canadian standard that's been written 5 years ago now, that talks about how we can manage the risks, how we can de-identify data. In the UK, they have the Code of Practice, really good document, explains a lot of the risks, explains sort of the terms that we use in this space, which I'll talk a little bit about briefly. And so it's a good read. These are both very good reads. But the problem is these standards don't necessarily tell you the how. They just tell you about some of the research and some of the things we have to consider in this data. But then there are other documents that actually do give a methodology. So the one on the left is a US one, and it doesn't give you an exact methodology, but it hints towards one. They're trying to be a little more broad and open based on the legislation in the US, but they want to give you some guidance to some degree. It's actually quite a good one. The next one is the sharing clinical trial data. So this is the stuff that we do at the Electronic Health Information Lab. We were developing a methodology to look at the risks, and we look at the same sort of risk assessments they do in IT security. Well, information, right? We're just talking about information. So this one, actually, the clinical trial data just came out last month. Institute of Medicine published this, and there's a whole chapter devoted to how do we anonymize data properly. When we do it properly, and this is the key message, the first ones we talked about, those were not done properly. All they did was take out the username. Of course you take out the username, you leave everything else in there, people are identifiable. We know this, right? So we looked at, if you look at things that are properly anonymized, that use these standards and guidance documents, what are the risks? And the risks are very, very low. We looked at all the research out there. We did a full analysis of this. And what we found is that the risks are very, very, very small. My favorite example is one in the UK. What the researchers did there is they went to their statistical agency and said, can you give us de-identified data? And we're going to match names to that data. And then you tell us how many, we'll send this back to you, we're not going to know who's who, but we want to know how accurate we were. And they were less than 0.01% accurate. They were basically random, completely random. They were not able to actually identify people. And that's when it's done properly. And you don't hear that story much because it doesn't have the same zing. Okay, so how do we do this at a high level? I'm trying to limit myself to my 10 to 15 minutes. So we make a distinction. I'm using the term anonymized, and other people talk about anonymous data, and what they really mean is masked data. They took out the names, right? We see the examples of this all the time. Another example is the taxi cab data, same thing. All they do is they take out those elements that we know are very identifying, the medical record number, the person's name, these kinds of things, right? That's masking, right? What we want to focus on when we talk about de-identification and re-identification risk are those other things in the data, right? The things, the movies that you like, the demographics that are represented in the data. And so we want to look at de-identifying the data. I call it hiding people in data, making people look the same. You take this group at the one table and you make them all the same age. Now you look at the data, you don't know who they are anymore. You don't know who's sitting at that table. That's the idea. But the key factor is we still want to learn things from data. We still want to use data, right? We're mostly focused in health privacy, so we focus a lot on health research, obviously. So we want to preserve good quality data. So again, that distinction. We talk about direct identifiers, right? This is the masking part. Get rid of the names. Get rid of the address. Get rid of the telephone number, the email, all these things that are clearly a direct link to the person. And then let's focus on what we call the quasi-identifiers. Those are the things that, in combination, the demographics make a person unique. Their age, their gender, their ethnicity, other things like event dates, maybe could be the transactions we talked about, the credit card payments, for example, diagnoses, all these kinds of things can identify a person. That's the part we're going to do the data mining, but the good data mining, the kind to hide people in data. So I'm not a bad guy. So how do we do this? So the first thing we do is we look at precedent, right? We look at Statistics Canada. What have they released in the past? They release a lot of data. They've been doing this for, let's say, 60 years now, right? Aggregating data, producing reports, public data that you can see online. There are ways to do this, right? So the first thing we do is we look at what have they done? What are the precedents that they have set? If you have very sensitive data, HIV patients, for example, you're going to set a much stricter threshold in terms of risk, right? You don't want there to be any leak whatsoever. So we use these to set a threshold based on some qualitative factors. Next, we can measure risk. There are ways to do this, and this is the part that people often don't realize, is that we can measure risk in data. We can look at those demographics, look at those event dates, and we can measure the risk statistically. Data mining, right? We're the good guys. We're on the good side. We're trying to find information that identifies people and then remove that information. Now, there's ways to do this. I mentioned briefly the idea of information security. There's a model of how you can do this. I won't go into those details, but the point is that we can do that. And then finally, we can transform the data somehow, make changes to it, make everyone at this table the same age, right? Boom, now we've transformed the data. We may have lost a little bit of granular utility to the data, but we can minimize that, right? There are ways to do that mathematically. So the ultimate goal we've been working on at the Electronic Health Information Lab are ways to do this, and we've broken it down into basically these steps, right? We assess the risk. We do a full risk assessment. A public data release, open data, very high risk. You look at StatsCan, it's aggregated. They have all kinds of techniques they use to make sure that there are large groups, large population groups in the data that they provide online. If you talk about a quasi-public or quasi-open data release, Well, this is the kind where you may have access to, anyone can sign up, but there are going to be some restrictions in place, like you cannot re-identify people in this data. That's sort of a standard one right there, right? Things that we can put in place. So we can assess the risk on the data. Once we've done, and that's pretty much, we have a checklist that you can go through, and we do go through to assess the risk, quantify the risk. And then we look at the variables. Again, this is the direct identifiers, the names, versus the quasi-identifiers, the dates of birth, for example. Classify that, group those. And then we can look at mapping the data to those data mining tools that we have so that we can produce anonymous data. And from that, we have done a lot of really cool things. We've done, as was mentioned, the Cajun Code Fest. We produced a data set of medical records that were then used for a competition where they were looking at ways to the theme was own your own health data, apps that they could create, therefore they could find things. Do cool things with the data. Another one was the Public Health Agency. We worked with them and we got them data they couldn't otherwise get. It's not that they weren't allowed. It's the Public Health Agency of Canada. They have a right to get certain data, but people didn't want to share it because of the risk, the privacy risks. And so we were able to get them data through this process. So there are ways to manage the risks. There are ways to share the data. And there you go. I'm done. Thank you.
Great. Well, thank you very much, and thanks for the invitation to come here and speak at this great symposium. So the topic of my presentation is national security and privacy on the internet. I think it's going to be quite complementary with what Michael has to say. We might have some differing opinions we've been known to in the past, but hopefully you'll be able to take away a more fulsome understanding of some of the issues that are inherent in this in the borderless internet, and thinking about what sort of impact the border actually has and should have in our decision making as we deal with these sorts of privacy issues. So I don't think that there's any doubt among people in this room or other places that there are privacy issues that are raised by the cloud, that are raised by just putting information in the hands of a service provider where the customer doesn't necessarily know exactly where that data is. And the principal issue is that the information is no longer under your direct control. You're relying on somebody else to secure that information for you. But what has become the focus of a lot of concern about cloud computing, and it's not just an academic one, is the jurisdictional impact, the fact that the information might no longer be in Ontario or might no longer be in Canada, or it certainly might be affected by other jurisdictions. And there's also the more routine issues about, and this came up in an earlier presentation, the sort of take it or leave it service agreements that you'll often see from providers in the cloud space, particularly in the mass market area. And then there's other concerns about the information might not be portable. You hand it over to a cloud provider. If they fail or if something goes wrong, you want to move to another vendor, what's your ability to take that information back and retrieve it, and what will happen when it's left there? But so often there's focus on the privacy issues without necessarily looking at some of the benefits that can really accrue by the use of cloud computing. The number one, the principal one, from a privacy point of view, because IT managers will point to the economics of it and the massive savings of using a scalable architecture that they can just rent time on, essentially, is that overall, most cloud vendors have more resources to devote to security and therefore privacy than most of the original custodians. That they're going to larger data centers, more professionally managed, more infrastructure in order to protect that information. And that's often independent of where that information is. And data is not as easily lost. We hear all the time about lost laptops, hard drives, things like that. If you're not having to take your information with you, you're accessing it remotely through hopefully a secure tunnel, you don't have to deal with those issues in the same sort of acute manner that others do. But let's look at it from the legal point of view and focusing almost entirely on the cross-border aspect. Under PIPEDA, and I'll use that as the model, although there are substantially similar laws in other jurisdictions and in some sectors, the original custodian is always going to be responsible for that personal information. You might be able to delegate the task of managing it on your behalf, but it's always going to be on your behalf. All the legal consequences, anything that goes wrong with the data, it's always going to stick to the original custodian. And it's up to the original custodian to make sure that they put in place adequate measures and safeguards, principally contractually, to make sure that the vendor treats the data as they would as the original custodian would, him or herself, or itself for a corporation. So how important is jurisdiction? And jurisdiction comes up in a significant number of ways, and I'm hopefully going to add maybe a little bit more color, a little bit more perspective on this. So jurisdiction comes up from a number of different aspects. There's the principal one, which is the one that's focused on most commonly, is where is the data? As though where is the data is the be-all and end-all. That answers that question. If that data is in Canada, it is going to be inherently safer than if it's someplace else, which is a bit of a fiction. Equally important, though, is who controls the data. If you're worried about the information being exposed to multiple jurisdictions, this is a very important question. The information can be in Canada, but if it's in the hands of a U.S. service provider, that data is now exposed to the U.S. legal system in a way that you might not necessarily have contemplated in. And so it comes into play in terms of where the data is, where the data also passes through. And I'm sure Michael's going to talk about, to a significant degree, the amount of interception of information in transit over the internet, which very often information over the internet is routed through multiple jurisdictions, and particularly as information crosses the border, it goes into a somewhat lawless zone. You have to worry about the nationality of the customer and also the nationality of the service provider, just using that as shorthand for to what legal systems are those particular players exposed. And the number one concern that we hear about, and that we've heard about for quite some time, is this thing called the USA Patriot Act, which came into effect shortly after the September 11th attacks. It's an omnibus piece of legislation that did a number of things. It's as thick as a phone book, but principally the issue is national security letters and the Foreign Intelligence Surveillance Act. National security letters are a form of administrative subpoena that can be issued by the Department of Justice to require the production of business records, or metadata as it's often referred to, not content necessarily, but perhaps in some cases. That's usually coupled with a gag order, which heightens the concern that if one of these national security letters is served on a cloud vendor, they can't tell their customer that they've been asked for it. Likewise, a national security or a FISA order under Section 215 is a court order from a secret court that meets in a bunker in Washington that generally rubber stamps requests by the U.S. Department of Justice on behalf of the CIA, the FBI, and the National Security Agency to hand over any tangible thing. And so it meets in secret. They're ex parte applications. Their orders are secret, and they're usually accompanied by gag orders. And when you look at the way that we think in a democracy that the courts need to be open, this is a sort of a chilling sort of idea. And so with attention focused on the USA Patriot Act, of course, if this is the regime in the United States, that's a really scary sort of thing. It really does significantly expand the circumstances under which U.S. law enforcement can get access to personal information. It amends, for example, the Foreign Intelligence Surveillance Act, which existed for quite some time, which was a tool that was designed for the spy versus spy. There's a notion that if the FBI wanted to wiretap the Russian embassy, that they would probably need some sort of court authorization. So there was this rule, a whole scheme that was put in place, including the secret court, that would allow them to make these secret applications. You certainly wouldn't want to give the Russians notice that you were seeking this application, have them show up and respond. And so those rules were expanded to deal with transnational crime, international terrorism, and terrorism financing. But those new powers of surveillance, arguably, they not only extend within the United States, but they deal with any aspect that has a connection, a sufficient connection and enough context with the United States. So certainly U.S. companies that are operating in Canada would have to worry about these sorts of things. Canadian subsidiaries of U.S. companies would have to deal with these sorts of things. And then also Canadian companies with a presence in the United States. And there's a long line of jurisprudence that talks about these sorts of things. For example, the New York City branch of the Bank of Nova Scotia was served with a subpoena to hand over customer records related to banking customers in the Cayman Islands. But because they were in New York, but they argued they were a Canadian bank, so they shouldn't have to do that, and the U.S. courts didn't have a whole lot of sympathy for that argument. So it's not, in that case, the data was in the Cayman Islands, in the possession of a Canadian company, but there was enough of a contact in the United States to make that sort of thing happen. So just where the information is not the be-all and end-all. And where this became a big concern for Canadians principally was when the British Columbia government proposed to outsource Medicare claims processing to the Canadian subsidiary of a U.S. company called Maximus. And the British Columbia Government Employees Union recognizing that they weren't going to get a whole lot of public sympathy just on the basis of lost jobs, focused on the fact that Medicare claims data was then going to be essentially wholesale provided to Big Brother in the United States, which resulted into an inquiry into cross-border outsourcing by the British Columbia Information and Privacy Commission at the time, which led to amendments to the Freedom of Information Protection and Privacy Act in that province. And so prevents public bodies in British Columbia from allowing personal information to be outside of Canada or accessed from outside of Canada. But notably, it still allows law enforcement agencies to, almost in an unregulated fashion, hand over information to their American counterparts, which kind of defeats some of the mischief, one would think. Alberta followed suit and passed amendments to their legislation in a very toned-down sort of way that simply made it an offense to hand over information about Albertans, again in the public sector, in response to a foreign demand for disclosure. And my province, Nova Scotia, came up with something called the Personal Information International Disclosure Protection Act, which does both of those things. Makes it an offense, well, actually you have to give notice to the Minister of Justice if you're served with a foreign demand for disclosure, and you can't allow personal information in the public sector to be outside of Canada or accessed from outside of Canada. Otherwise, under general Canadian privacy laws like PIPEDA, there's no such restriction, but certainly the accountability principle comes into play and the safeguards principle comes into play. But very often in discussions about this, you have this imaginary boogeyman on the other side of the border down in the United States who's siphoning up massive amounts of information, which is absolutely true. But I don't think Canadians are necessarily as aware, although they're becoming much more aware of the national security boogeyman that exists within this country and the fact that the border has become significantly less relevant in these discussions. Very few people were aware of, and there's not a lot of consciousness of, something called the Anti-Terrorism Act. Obviously, C-51 is getting a lot of attention. That's the Anti-Terrorism Act 2015. But the Anti-Terrorism Act of 2001, which came into effect on Christmas Eve of that year, is similar to the USA Patriot Act in that it amended the Criminal Code, the CSIS Act, and the National Defense Act to do a whole bunch of things. Not many of you would be aware necessarily that there is a secret court in this city that meets in a bunker. It used to be on Metcalfe Street, that's now in an undisclosed location, where federal court judges meet ex parte and receive representations from the Department of Justice to issue warrants under the CSIS Act. And those warrants actually can go much further than the Foreign Intelligence Surveillance Act orders. They can allow CSIS officers to break into premises stealthily, to install devices, and then go back later to replace the batteries in those devices, and then obviously to intercept communications and do all those other sorts of things. So these are ex parte secret applications, and in fact, one of these applications is going to the Supreme Court in the next little while. They allow for interception of communications, the usual sorts of warrant things. We also have this significant amount of information sharing that takes place. People here have probably, hopefully heard of the Five Eyes, which is the United States, United Kingdom, New Zealand, Australia, and Canada that participate in this massive infrastructure of global surveillance. And so that's information sharing at one level where they have shared databases, shared projects, and shared common initiatives. But there's also just a huge amount of information sharing that goes across the border on a regular basis, formally and informally. We have a mutual legal assistance treaty with the United States and with other jurisdictions that allow, for example, if the FBI wants information, they are able to go through channels through the US Department of Justice to the Canadian Department of Justice to obtain a warrant in Canada to obtain that information for the FBI investigation. But then we also have informal arrangements which are allowed under the Privacy Act and other provincial public sector privacy statutes, which, preferably they're in writing, but in many cases I think they're a nudge and a wink, and you just ask Mayor Arar about the consequences of this sort of information sharing on a kind of wholesale and unregulated sort of way. And then also, one thing to consider, and this has come up in some of my work with clients, is that in some cases, depending on the nature of the information may in fact be safer from the United States authorities in the United States, where it's subject to the Fourth Amendment. Because if that information is in Canada, US authorities can hack across the border with complete impunity. And if that is your principal risk, then in fact, it may in fact be better to keep it in the United States. And so it just highlights the messiness and how complicated these sorts of things are. And so the reality is, if you're concerned about the USA Patriot Act, you should be equally concerned about the Anti-Terrorism Act. And we've seen through the Snowden documents significant abuses of the privacy of Canadians under the guise of, and through the agency of CSEC, or now CSE as they've changed their name, and CSIS. We have a secret court that issues the same sort of secret orders, and they do get issued. Many of these, you sometimes hear about them. In fact, you can find some of the redacted decisions in these cases online on the legal databases, but it happens, and I think that's a revelation for a lot of Canadians. Canada has the same sort of authority that the Obama and the Bush administration before it used for tapping international cables for traffic coming into and out of the United States. Canada has exactly the same sort of powers under the National Defence Act, where without a warrant, the Minister of National Defence can authorize the tapping of the global information infrastructure according to that part of the mandate of CSEC. So a huge amount of hoovering of information takes place at the borders. And then there's a significant amount of just general information sharing. So if you want to protect information, at least rather than, and I see a fair amount, oh my God, we can't have it in the United States, or oh my God, we can't have it here, there, or other place, you actually need to take a step back and you need to look at all the different connecting factors and think about really to what way does jurisdiction play into your decision making. Starting with the first principle that the original custodian remains responsible for all of this personal information and needs to make informed choices. And then, at least in my view, it needs to be a risk-based approach. What's the sensitivity of the information? What's the nature of the information? Is it something that would be of interest to a national security authority or otherwise? What's the risk to the data? Is the risk that national security authorities will get their hands on it or that hackers will get their hands on it? What are the possible consequences that could happen? And then to what extent does jurisdiction play into that? And that also plays in terms of you have a contract with a service provider, is that actually going to be enforceable wherever the data is and wherever that service provider is located? And think about how can those risks be mitigated? And it's no longer so much the focus, the location of the data, as it needs to be also looking about the nationality of the service provider, but also recognizing that even then, Canada is just as mischievous as the United States when it comes to these sorts of things. And so are there technological or other means that can be used to mitigate this sort of threat? I think you need to assume that information as it crosses over the border is being collected, cataloged, and indexed and thrown into a database somewhere. So information in transit on the open internet needs to be encrypted. We're seeing the development of new technologies for cloud vendors, for example, where they call it zero knowledge, where customer information is encrypted on the platform, and in fact the service provider does not get access to it or could not have access to it. So if they are served with the demand from a national security authority, whether it be in Canada or in the United States, they're simply not able to provide any sort of a clear text. But at least the takeaway from this is to kind of step back, understand what in fact are the risks, and it not necessarily are they legal or political things that you can mitigate through those sorts of channels, but hopefully through technological means as well. So, thank you so much.
Thanks. Great. Well, thanks very much. Thank you certainly for the invitation to speak. Thanks to the OPC, both for sponsoring this event and even more for its ongoing support of privacy research in Canada through the contributions program. It makes an enormous, as I think people in this room all know, it has had an enormous impact on, I think, our knowledge and our ability to engage in cutting-edge research across the country, and it's a program that is enormously worthwhile. And thanks as well to Madeleine Sagener, our Executive Director of the Centre for Law, Technology and Society at the University of Ottawa, who pulled all of this together in amazing fashion. So thanks so much for all of that. So the title of my talk, as you can see, is Why Watching the Watchers Isn't Enough. This is actually taken out of a chapter in a forthcoming book, so a little bit of an infomercial, Law, Privacy and Surveillance in Canada in the Post-Snowden Environment. It's being published by the University of Ottawa Press in a couple of months. Has contributions from people like Craig Forsyth, Kent Roach, Reg Whitaker, Tamir Israel, Christopher Parsons, and others, and it is available under open access, so it'll be free to download. And what I want to talk about is essentially my contribution to that book as well. The shorter title, I guess, for this talk would be Against Oversight. And my argument here is not that we ought not to focus on oversight. I think that's a given for most. But rather the emphasis that we have seen and continue to see on oversight as somehow being the solution or one of the core mechanisms by which we can deal with the surveillance revelations over the last almost 20 months, I think in some ways may lead us to miss the forest for the trees. So when we first saw Ed Snowden with this picture, and for those that haven't seen Citizen4, where you get to see him just before and just after, it's a movie that you must see. The story that we started to tell ourselves, at least here in Canada, amongst many, as the revelations began to come, around metadata collection, around the broad data mining with respect to internet-related companies and the PRISM, and frankly, the stories continued and continued and continued, was by and large that somehow this wasn't us. This was the United States, in the same way that David talks about that US boogeyman. There was here the NSA boogeyman, so to speak, and that while this may be happening and Canadians may well be affected, in some way this wasn't happening in our name. This was the US engaged in this kind of surveillance. Well, as we know, it didn't take long. There are lots of revelations. It didn't take long before we learned that that story just doesn't hold any water. We now know that the Snowden story is also our story. We know that the metadata programs that we see occurring in the United States have been occurring here too, and at times with real concerns from those who are charged with providing some amount of oversight in terms of trying to deal with it. We know that the kind of spying revelations that have come up through the NSA are our story as well, as we know that our agency, CSE, has been engaged in similar kinds of activity. We know that we actively cooperate at times on Canadian soil to engage in the same kinds of activities, whether at the G8 or G20 or otherwise. We know the so-called airport Wi-Fi tracking story, the seeming effort from some of our own officials at the CSE and elsewhere to try to almost impress their counterparts by showing just how good we can do this too. In the airport Wi-Fi example, the illustration of how tapping into IP addresses there could allow or might allow for the tracking of traveler movements once they moved outside of the airport. And most recently, the revelations that our agencies have been tracking or downloading tens of millions of downloads every single day, and then using that information in the hope of tapping into other databases to directly try to identify persons of interest. So identify documents that might be uploaded to various file sharing sites or other sites that allow people to post this information online, identify the IP address associated with that, and then go to other databases, sometimes run by the GCHQ in the UK, that have billions of cookies in there, and try to use some of that information with the other information to try to identify precisely who may have either uploaded a particular document or downloaded a document. And then, of course, just in the last couple of days, the CSE engaged in collecting hundreds of millions of email messages that Canadians send to their governments every single day, and using that to track certain sorts of activity, and then layering on top of all of that, literally as we speak, Bill C-51, with the committee today talking about how many hearings they're prepared to have to talk about this piece of legislation that, as I'll talk about in a few minutes, has real implications for some of these issues as well. So the story that somehow Canada isn't involved or isn't active is clearly not true. And so the story that we then tell ourselves instead is that the way to deal with this is oversight. Our oversight is faulty, we hear it all the time, and so what we need to do is to fix that oversight. Privacy commissioners or former privacy commissioners arguing that the way that we address this is with better oversight. Opposition parties taking the stand that the solution lies in better oversight. Private members' bills, as Joyce Murray's, for example, from the Liberal Party, focusing on improving oversight. The media focusing on improved oversight. Discussion in the House of Commons focusing on improved oversight. Op-eds talking about improved oversight. And I'm here to say that this is not just about oversight. Oversight, in a sense, provides, in my view, an easy out. The ability for those who don't want to directly criticize or to be seen to be directly criticizing legislation for fear of being seen as being weak on terror, to focus instead on the process issues, that we have to instead deal with oversight. Well, I'm here to say that even if we fix the oversight, and make no mistake, there are clearly improvements that can be made on oversight, we will not have fixed the underlying problems. Now, in some ways, this is perfectly obvious. In the moments after some of these revelations, the existing oversight from the CSE Commissioner, both on the airport Wi-Fi story and immediately after the initial Snowden revelations, unusually took directly to the public to say, I'm on the job. I have oversight responsibility, and have no fear, we have reviewed what's taking place. We were aware of what is taking place, and it is consistent with Canadian law. Now, maybe the Oversight Commissioner, the CSE Commissioner in this case, is wrong. Maybe the oversight is indeed faulty at that level. But what if he's right? What if, in fact, what is taking place is legal, is consistent with Canadian law? And if that is the case, then no amount of new layers of oversight, whether new parliamentarians or other mechanisms that we might identify to allow for a more robust oversight, is going to do anything to alter the kinds of activities that we have seen revealed or have been revealed over the last 20 or so months. So where do I think we must at least equally, and I would argue even more, focus our attention? Well, one area certainly is on the issue of metadata. We had references to that de-identification, re-identification earlier on the panel, but around the issue of metadata, what we've experienced in Canada over the last number of months is a battle, in a sense, between the experts who, having studied the issue about what metadata can reveal, have been locked, in a sense, in a battle that they are losing with politicians who say, I can't hear you. When you say that metadata allows for the disclosure of identities, when you say that metadata has been used in numerous studies to allow people to get into the personal information in ways that we previously thought of solely with content, in a sense, I can't hear you. When General Michael Hayden in the United States says we kill people based on metadata, I can't hear you. When the Supreme Court of Canada in R versus Vu points to the privacy import of metadata, the politicians again and again say, I can't hear you. And so when repeated witnesses appeared on Bill C-13, the lawful access legislation that in a week or so will take formal effect, and to talk about the standard, the threshold that was established with respect to essentially metadata, transmission data warrants, the response again and again was, I can't hear you. This isn't content, and a lower threshold is perfectly appropriate. And yet we know now that we engage, and we have engaged in these metadata programs for some time, and that the level of protection that in fact has been accorded to the privacy associated with that information has been woefully low and not nearly commensurate with those who have expertise in the area have said it deserves. So too with the issue of jurisdiction. And David highlighted some of the jurisdictional questions, I think, really nicely in talking about how that data flows freely across borders. Now, many of you will know that the CSE's mandate is very often to say that they cannot target Canadians. And yet I would suggest to you that when we learn of the capture of tens of millions of downloads every day, what is by any reasonable definition mass surveillance, you cannot at the same time argue that you engage in mass surveillance and at the same time argue that you do not target Canadians. In a sense, what our agencies would like us to believe is that if you target everyone, you effectively target no one, and so are therefore consistent with the law because they are hoovering up tens of millions of downloads that, yes, some of which may come from Canadians, but we are not directly targeting those Canadians. Yet we know that if you indiscriminately capture all of this information, tens of millions of downloads on a daily basis, you know that effectively Canadians are targeted because you are targeting all. And yet the interpretations that we see, at least to date, presumably from our Oversight Commissioner, is that somehow this is consistent with the mandate. It is difficult to see how. So too with the way in which information moves effortlessly across borders. Another chapter in the book that I reference comes from Andrew Clement, who talks about the boomerang effect, where we learned that for some of the largest providers in the country, they refuse to exchange traffic with other Canadian providers here in Canada. And so if you are a subscriber with some of the largest ISPs in the country, where you are sending messages, where you are visiting websites, the exchange point takes place not domestically here in Canada, but rather in the United States, very often in Chicago. And in doing so, it immediately falls into that NSA surveillance activities that we know so much about. We must find ways, I would argue, to deal with jurisdiction and to be more honest about the ways in which our laws, which seek to somehow differentiate on a jurisdictional basis, are been rendered largely meaningless at times as that jurisdiction is blurred. We heard also from David about the information sharing that takes place as between agencies, the Five Eyes Consortium and the like, and that notion that somehow we can hive off what Canadians are doing as opposed to others, and we hear insistently that somehow they each operate on their own, yet in some level of cooperation. Yet when we learn of some of these programs and see the degree to which not just that there is cooperation, but that there is accessibility as between databases to provide a far larger data pool, I think we must surely recognize that these agencies work together in a manner that even where there are legal restrictions on what our own agency does, many of those can effectively be circumvented through this Five Eyes work. We know too about the limits of domestic protections here in Canada through PIPEDA and otherwise, with still today the largest telecom provider in the country not providing a transparency report. We've seen it from others, but Bell in particular, standing to still today and refusing to disclose to their millions of Canadian customers, not on an individual level, but even on an aggregated level, the kind of cooperation that they provide to law enforcement as part of these requests is, with all respect, positively shameful. And what I would argue it calls for is a clear mandate within the law to ensure that not just that this can happen, it's fairly clear that it can, given that we've seen TELUS and Rogers do so, but rather that it must happen. We know, too, the limits of all of this when we take a look at the RCMP audit conducted by the OPC. It's an important audit, to be sure, and it is, in a sense, an example of some of the oversight that we have. But when our own Privacy Commissioner's Office can go into an audit and find at the end of the day that they can't actually do the audit because there isn't the data there, because there isn't the record keeping there, the kinds of domestic protections that we have are simply inadequate. We know, too, that the U.S. protections, once this information makes its way into the United States, are also simply inadequate. Those constitutional protections that David talked about don't accrue to me. I'm not a U.S. citizen. When my information is elsewhere, I don't enjoy that level of protection. It is a two-tier sort of protection that exists in the United States to the extent to which there is that kind of protection. And it is an enormous problem that our government should be advocating on our behalf, but given where it stands, even domestically, I'm not holding my breath. And then finally, there is the changes that we see taking place, particularly the information sharing provisions within Bill C-51. If the Privacy Act was about anything, dating back now decades, it was about providing protection for the information collected by individual government departments and ensuring that the sharing of that information enjoyed a certain amount of protection. When one looks at what C-51 does on information sharing, identifying 17 different departments and agencies and ministries who may all now cross-share information if this is passed for reasons that extend so far beyond just terrorism to include just about anything from an economic perspective and otherwise. The very rationale of this legislation, I would say, is positively gutted. Indeed, even more, there is the catch-all provision within this legislation that says that at the end of the day, not only can it be shared amongst these agencies, but can be shared to any person for any purpose. The very notion of privacy from our own governments is lost within Bill C-51, with a government that, with all respect, at least earlier this week, had been talking about going through this bill with no more than 2 or 3 days' worth of hearings. And so we talk a lot about oversight. Indeed, we even talk about it within the context of C-51. It is necessary, to be sure, but it is by no means sufficient, because the danger, I would argue, that we face is that even if we get the oversight right, What we leave in place is a legal framework that provides us so little protection that no amount of oversight will make a true difference. Thanks very much for your attention.